for today. First and foremost, sorry for the slight delay. We had a small technical difficulty in setting up the presentation, but now it should be fully well and visible. Like I said, my name is Martin, and I will be your moderator today. And the goal and the aim of this webinar series is to continue with our pan-European discussions, even during the times of crisis. And our goal is to bring you topical sessions on a weekly basis. And our first presenter of today is Mr. Cian Farrell, who is the head of legal at Huawei Ireland. And he will be talking about the effects of the pandemic in both common and civil law jurisdictions. Cian, the floor is yours.
Thanks very much, Martin. If you can just pop up the slides on the screen. I know we had some technical issues there. Just it's not up on the screen. But hi, everyone. My name is Cian Farrell. I'm obviously head of legal for Huawei Ireland, and I have been obviously with Huawei Ireland for over 2.5 years, and this presentation is about basically looking at a pandemic in the context of force majeure, frustration, and limitation of liability clauses, and how they play out from a very high level, from a civil law and a common law jurisdiction perspective. As you're aware, we're obviously in the middle of what is a crisis throughout the world, particularly in Europe. And there is many issues arising across the business world, supply chain, the ability to deliver goods, supply and demand collapse, etc. So what we'll go on to do is in slide 2, I'll just tell you a little bit about Huawei if you're not aware of the company. Huawei is obviously a Chinese company, and it has approximately 200,000 employees, 80,000 of which are research and development employees, because like a lot of technology companies, research and development is vital in terms of progressing and improving upon the technology offering we have. We're located in over 170 countries at the moment. We're, in terms of brand recognition, we're deemed 74th in the Interbrand's top 100 best global brands. That is the 2019 positioning. And Huawei is the 61st largest company in terms of the Fortune Global 500 list. And that's actually quite a jump up. It's almost 11 places in just over 2 years, which is quite a sizable jump. In terms of the next slide, I'd just like to briefly describe Huawei Ireland and what we do here in Ireland. We do both selling of carrier products, and we also have a services division. We also obviously have a consumer division, that's your mobile phone and laptops, etc. And then we also importantly have a research and development center here. So in terms of the size of Huawei Ireland, we've got approximately 500 direct and indirect jobs, whether they be employees or contractors or staff. We are looking to build upon that number. The target was set at 100 jobs to be created between last year and 2021, and 65% of all jobs are recruited from the local market. Huawei started in Ireland in 2004. We're headquartered in Dublin. We've got 3 R&D centres, which comes as a surprise to a lot of people, both in Dublin, Cork and Athlone. And in Ireland, 2.5 million plus are serviced by Huawei products. And obviously our key clients are household names like Air, Vodafone, BT Ireland, Imagine and Cyro. In terms of research and development, Huawei committed 70 million euros in terms of research and development activities, and that's to cover the period of 2019 to 2021. one big significant investment was approximately 6 million in the Lero Software Centre based in the University of Limerick. And the research and development team are very proud of their award-winning video intelligence research. So let's move on to the main topic, slide 4, in terms of I thought that in the context of a pandemic, people are looking at contracts with a view to either renegotiation of the terms or changing of the terms, or in a very, very difficult situation, they may look to terminate. And there is quite differing positions if you're in a civil law as opposed to common law jurisdiction. Naturally, as somebody told me the other day, I think it's obviously the first clause you may look to is whether you have a termination right for convenience and notice. But let's say you're locked in for a period of time that is uncomfortable or untenable, then the doctrine of frustration, force majeure, and limitation of liability provisions are of paramount importance. And obviously, if you're aware, the common law jurisdiction is very much based on what's in the contract, with some recourse to the courts in terms of common law doctrines or the courts of equity. But generally, what's in the contract is deemed to be the governing position between the parties, whereas civil law, as many of you will be aware, will normally have a civil code that could be relied upon above the contract itself, or the contract may be silent by virtue of the fact that the civil law code actively manages that particular situation. So in terms of moving on, I'll go down to slide 5, frustration. From a common law jurisdiction perspective and somewhat of a civil law jurisdiction, a frustrating event is something that is obviously unforeseeable and where there is no fault by either party. The contractual rights and or obligations have basically been materially changed to such an extent that the contract has radically changed. So you're basically in a position where neither of the parties probably would have entered into that. The parties wouldn't have entered into the contract but for this supervening event. And a lot of time people ask for the type of examples that would amount to a frustrating event. So the examples would be, one would be where you hire a specific band and the singer gets suddenly sick, or in some unfortunate circumstances dies. That is generally deemed to be a frustrating event. Another example, which is quite an old example, is one where somebody rented a flat to see the coronation, I think in the UK, of either the King or the Queen, and that coronation was cancelled. And in that event, the court in the UK, England to be precise, deemed that to be a frustrating event, and the contract was cancelled. Other examples of it is where you buy specific goods that can't be replaced by similar goods, and the contract is very specific to those goods, and let's say the goods disappear, maybe because of an act of God or something like that. Again, the courts in the past have held that to be a frustrating event. But so we'll move on to the next slide. The problem from a common law jurisdiction perspective is that common law jurisdictions tend to have a hands-off approach, whereas a civil law jurisdiction approach is generally be deemed to be interventionist. Basically, in common law jurisdiction, the belief is that parties should be allowed freedom to contract, whereas in civil law jurisdictions, there's much more of an equitable or fair intervention approach to allow to bring the parties back to a position if they had been aware of that supervening event. there's obviously pros and cons to both approaches, but it does appear that the civil law approach tends to result in a better position, because there's more tools open to the judge in terms of reaching a fair conclusion, whereas in a common law jurisdiction, paramount importance is given to the contract, and only in very limited circumstances will a court impose a doctrine of frustration. Another point to bear in mind, that given that frustration is such a difficult remedy to obtain before a common law court, that many instances now you will see virtually 90% of common law governed commercial contracts will contain force majeure provisions. And force majeure from a common law perspective is generally seen as a lighter form of frustration, because you can actually set out what would be deemed a force majeure, whereas frustration basically says that the contract is dead in the water because it's radically changed, whereas force majeure allows for certain steps and allows for the contract to continue to exist, subject to possibly a termination right. If the doctrine of frustration is applied in a common law jurisdiction, generally the losses lie where they are, but in some common law jurisdictions, legislation has been implemented to provide for some kind of fair balancing of the losses in such circumstances. But strictly speaking, if the doctrine of frustration is applied, the contract is terminated and the losses lay where they are at that time. However, there is some case law in common law jurisdictions, in the UK in particular, where they've come up with the concept where if you've paid for something and you haven't received it, then there's a lack of consideration, and therefore there's not technically a binding contract to that element, and therefore you should get your money back, because obviously, as you're aware, there can be situations where you make prepayments. In terms of civil law jurisdictions where a frustrating type event occurs, there's generally to be a reassessment of the risk and a realignment of that risk by the court, so that the courts try and find a fair balance. And that's why it's kind of termed an interventionist type approach, because it may be difficult to judge whether the parties would have allowed that to be the position if they had known that supervening event was going to happen. Naturally, a lot of people would argue that that an unforeseen event is an unforeseen event, and therefore, both parties shouldn't be, one party in particular shouldn't have to bear a disproportionate part of the loss. So again, as I said, many people may argue that the civil law position is a lot better, whereas given that force majeure is a very common contractual provision now in common law jurisdictions, that the courts, by being hands-off, have pushed contracts to be clearer and more succinct. But again, we'll see in the next slide that there can be problems even where the parties have provided for a force majeure type position. So in terms of force majeure, in common law jurisdictions, force majeure is generally a contractual construct, whereas in civil law jurisdictions, obviously people look to the civil code and legislation. So my understanding is in some civil law jurisdictions, force majeure provisions are not common, because it is felt that the applicable civil code or legislation adequately provides for it. In other jurisdictions, civil law jurisdictions, my understanding is that sometimes the civil code is so limited in scope that people prefer to try and have force majeure provisions in the contract with a view to the parties being clear on what the steps are. So in terms of common law jurisdictions like Ireland and England and Wales and New York, you will have a definition of force majeure in the contract. And that definition, there's generally two broad categories. One is what you call they provide an exhaustive or limited scope definition, in which case, if the event does not come clearly within that definition, therefore is not a force majeure, and therefore the force majeure provisions don't apply. Typically, force majeure definition is given an expansive or non-exhaustive list of events, so that once you come within that broad scope, you could argue that the force majeure provisions apply. The problem has been is that in many instances there's been arguments that if the word endemic or pandemic have not been used in any of the definition, even though it contains a non-exhaustive list and says beyond reasonable doubt, there is argument to say that maybe it comes within the act of God. Other lawyers argue that it doesn't. So there may be some toing and froing as to whether a force majeure provisions actually apply, because the COVID-19 situation or any other type of pandemic may not be deemed a force majeure for the purposes of that definition. There usually is no assistance in regards to force majeure definition in the legislation of common law jurisdiction. It is purely a contractual matter for the parties to set out, be clear upon. In civil law jurisdictions, as I said, it's generally force majeure can be part of the civil code. And in some instances, governments play a part in terms of designating something a force majeure event. So, for example, the Chinese government deemed COVID-19 to be such an event, and therefore that assisted greatly in parties that had problems either delivering goods or receiving goods. And that again shows you where sometimes having a third-party interventionist approach can make things very cut and dry and clearer. Obviously, people might argue that it still doesn't go to the tenure of what contracts are, so the agreement between two parties. But again, when you have an unforeseen event, sometimes it's difficult to really provide for that. So, as I said, in civil law jurisdictions differ different civil law jurisdictions actually can differ on what a force majeure is and the scope of its application. So, I believe in Germany you have much a wider scope of application in force majeure, whereas in other civil law jurisdictions there may be very specified circumstances in which a force majeure can be applied under a civil code. In terms of common law jurisdictions, typically your force majeure clauses will have one notice, so the impacted party will typically have to notify the other party. So if you're delivering goods and or services, and for example under COVID-19 enacted legislation, you can't carry out those services or goods, or they're impacted in some way, you will typically have to deliver a notice to the other party. The problem that has arisen recently in terms of these notifications is that the party doesn't really know, given how quickly the legislation has been acted, particularly lockdown legislation, whether they come within the legislation in terms of that they can continue to do what they're doing, or that they have actually have to stop. So there's been problems there. In Ireland, we have a list of essential services and non-essential services, and the essential services list and guidance can be quite broad. Another problem is even if you come within the type of business that is allowed to continue, your supply chain may be affected. So again, the problem with the notice is that you're notified of a force majeure, but you may not be entirely sure of the impact at that time. And then typically in a common law jurisdiction, you will have a clause that tells what is to happen subsequent to that force majeure in terms of business continuity plan or something like that. Again, there has been some confusion in common law jurisdictions around the nature of the suspension of the contractual obligations. And to give you an example of that is, for example, in Ireland, people carrying out construction work may be told that they're non-essential services, but they still need to ensure that they comply with health and safety legislation. So again, the rising of the COVID-19 pandemic has caused a lot of issues around people being told they have to stop, but then there's conflicting legislation which basically goes on to say that you have to adhere to health and safety. So particularly road construction and building construction, where they may have to continue to safely close off the works before actually stopping. So that's caused a bit of issues. Typically in force majeure provisions, there will be some provision that states that the party impacted will have a duty to mitigate. And that again means that if they can work around it or somehow stem the losses, because typically a party will have a right to claim or at least apportion the costs for the impact of the force majeure. Again, the number 4 there on slide 8 would be that you have an automatic extension of time. So if the force majeure was the last 4 weeks, the contract would extend by 4 weeks, and or you would have a termination right. And typically the way force majeure provisions in common law jurisdictions are drafted is that the force majeure would have to last for, and an important terminology is consecutive, and typically it's either 30 days, it could be 60 days, or it could be less, but 30 consecutive days. So if you have a force majeure event that happens, then basically it stops and occurs again. And that is a live possibility in the COVID-19 situation, where we have lockdown, and where if a government rushes to ease those lockdown provisions, and then the COVID-19 takes hold again in parts of any country or in any villages, etc., the lockdown may be reenacted. And that's where the consecutive wording could be problematic. So you could be in a force majeure provision for a lot longer than the parties envisaged. It is important to note that while civil law jurisdictions have an interventionist type approach, that courts will obviously pay attention to any force majeure provisions in a civil law governed contract. And I think this has been highlighted in the Netherlands, where the courts have said that they will obviously pay attention to the force majeure, because ultimately they're trying to reach a fair conclusion, but also fairness may be dictated to what was in the minds of parties at the time of contracting. So that has caused a little bit of confusion, because you're almost getting into a common law jurisdiction approach, but it does seem to be the common sense approach in terms of how the Dutch approach it. Then we're coming on to the next set of slides, which is slide 9, limitation of liability provisions. From a common law jurisdiction, this is a vital clause, and actually normally causes a lot of negotiation and debate around where the matters should lie and the risk should apply. So typically, the party that is carrying out the main obligations of a contract in a common law jurisdiction governed contract, they will insist upon some form of limit of liability and or an exclusion of liability. So basically, in common law jurisdictions and civil law jurisdictions, the courts give parties a wide autonomy and contractual freedom to negotiate what their limits of liability and their exclusion of liabilities are, but these are not unlimited. And typically one would say that a civil law jurisdiction, that there is much more of kind of inhibitors on where you can get to, whereas in common law jurisdictions, there is generally a freedom to contract subject to certain things. So for example, you can't exclude liability for debt or personal injury. In England and Wales, they have the unfair contract terms, which plays its part where parties attempt to take advantage of their leverage in negotiations. So where you have a very large multinational company negotiating with a very small supplier, the multinational company in England and Wales would have to be, well, if the contract's governed by the law of England and Wales, the larger party with a huge degree of leverage would have to be very careful not to go too far in taking advantage of that. Otherwise, a court could open up, particularly the limitation of liability clause. In Ireland, the common law which is a common law jurisdiction, the burden of proof is on the party asserting the limitation or exclusion applies. That can be that obviously evidential burden can sometimes be difficult, but many times it's just a procedural thing, and it's not something to be too concerned about once the contract is very clear. In terms of caps and limits, again, as I stated, common law jurisdictions, once reasonable cap is generally considered to be enforceable. In terms of what the cap is set at, typically in common law jurisdiction, the contract value is used as a starting point. So there are numerous ways in common law jurisdictions that one can limit the cap, but typically one starts out at around 100% of fees paid. If you're trying to be clever, you will try and say fees paid rather than fees invoiced, paid and invoiced, because obviously paid is a big thing. And secondly, you'll normally try and restrict it to the previous 12 months. But again, it depends on how much leverage you have in the negotiations. Typically, parties come to around 100% of all fees paid and invoiced up until the time of the claim, and it can go as high as 200%. But it all depends again on the leverage. Civil law jurisdictions, it's helpful in terms of those negotiations, but typically you would have statutory limits, which again I think helps fast track the contractual negotiations. So it's something that common law jurisdictions haven't really taken on board because they're obsessed with the freedom of contract contact and a hands-off and to let commercial parties negotiate. But I think personally, from my view, is that given where we're going in terms of very large dominant companies in our society, that it may be the case that there could be some intervention to provide some kind of limit to what liability can be put into the contract, and also the exclusion or the de minimis level. So that's just something for consideration. Another part of liability provisions in common law jurisdiction is the concept of liquidated damages versus penalties. Liquidated damages are a reasonable estimation of the actual damages, and courts will uphold those. So it is recommended, particularly any contract governed by a common law jurisdiction, is that you ensure that whatever liquidated damage amount you put into the contract, that it is reasonable in the context of the loss and puts you back in the position you would have been but for that breach. So this has been typically very difficult in some contracts to estimate what that loss is, but once it comes in and around, and it's recommended that you put in a worked example as well as to how you reach that amount, so that you can show to a court that the liquidated damage isn't a form of penalty, rather it's a form of compensation that is to cover you for the actual loss you incurred. As you can see in the top right-hand corner of slide 11, the general rule in common law jurisdictions is for any party in a position of negotiation strength to ensure the limitation of liability provisions are carefully drafted and do not attempt to exclude all liability, or particularly to exclude liability unreasonably. That comes from, again, as I said, mainly common law jurisdictions where they have legislation that have a fairness right of courts to intervene. So that basically is a common law courts acknowledging that that very much the way the civil law thought process is that you need to intervene to prevent a totally unfair situation arising. And that is because in many contracts you will see where there's total lack of balance in terms of negotiation strength. You will see the limit set at a very low level. But the warning there is that that could end up being declared a unenforceable provision, in which case opens the contract up. So again, that's something, if you're drafting a contract, you very much have to be very careful on in a contract that's governed by common law jurisdictions. The big difference between common law and civil law jurisdictions is penalties. In common law jurisdictions, penalty is a monetary charge unrelated to actual harm and generally considered to be unenforceable. And the reasoning the courts have come up with that is because they feel that penalties, if you have penalties in a contract that allow a party to almost benefit if the penalties arise, that will mean that that party may look to make that situation arise in the contract because there's a monetary gain to be had for that. So therefore, penalties are, if a clause is deemed to be a penalizing clause, or the amount is to be a penalty rather than a liquidated damage, then that could be unenforceable. And again, that comes down to your negotiation strength. If you push your hand too far and too unreasonable, that could end up actually defeating the purpose for which you put the amount in. So again, that's where worked examples and kind of evidence that the liquidated sum is some kind of measure of what has been lost by the party who requires compensation. In civil law jurisdictions, my understanding is that liquidators and penalties generally considered to be enforceable. That comes down to the fact that the parties have agreed it, and therefore it should be. But you do have those statutory limits. So it is interesting that you have a hands-off approach generally in common law jurisdictions, and an interventionist one in civil law jurisdictions that is somewhat overturned in the situation of penalties. But one could argue that there is potentially statutory limits in civil law jurisdictions. In common law jurisdictions, particularly in Ireland and the UK, it's important to note that many of the commercial contracts, they will seek to exclude limits of liability so that it's uncapped liability for certain heads of losses, and particularly around intellectual property rights, data protection, confidentiality, and important indemnities. So what the argument there is that where a party is, let's say, licensing IP, that IP claims can be so significant and they go to the core of the contract that it's unfair that the party who's paying should also bear the risk of some claim, third-party claim. So typically you'll see IPR provisions that allow for the handing over of the claim to the licensing party or the party who's provided the IPR rights. Data protection is another big one, particularly in the context of the GDPR that came into force in May 2018. The sums of money can be huge, and again, a party will look to seek to get those, particularly where it's outsourcing processing of personal data. This can be a real bone of contention because there may not be a lot of money in the contract in terms of the party doing the processing doesn't get isn't making huge amounts of money, and therefore you can have a real toing and froing over this. And more importantly, it could end up in having a separate caps. So you have one general cap, and then you have separate specific caps in terms of these heads of losses, particularly data protection. Confidentiality is normally not argued over that much. It's not something now that comes up too often in terms of it's very difficult to prove that confidentiality is breached unless you have an email or you have someone willing to give direct primary evidence. Indemnities is a big thing because in common law jurisdictions it's very common to seek indemnities, and the difference between an indemnity and a warranty is an indemnity, once you show the loss, then you get the amount, whereas with a warranty you typically you have to show that there's been a breach and that the monies you seek come as a direct result of that warranty breach, unless you particularly normal in limitation of liability clause to exclude indirect losses. So indemnities are a big thing in common law jurisdictions, and specific indemnities are typically sought to be uncapped because they think it's a very specific risk. You will have a lot of negotiation where their indemnities in general should be uncapped. I think that's an unfair position, but it's something that many lawyers will argue. And therefore, normally the compromise is that certain specific indemnities are uncapped. The other way around it is to turn an indemnity, which is indemnity in name only, but in form it's actually a warranty. And that's where you will see in common law jurisdictions where they put preconditions, and they will also put a duty to mitigate, which effectively turns the indemnity into a warranty. So that's something that can be borne in mind, particularly in common law jurisdictions. As I've stated before, in common law jurisdictions, there's not much of an intervention on the cap and liability, provided it is reasonable. And as I said, the contract value is often used when calculating the overall cap. Civil law jurisdictions, caps and damages are generally valid, subject to statutory limitations. So you can see in terms of the three topics that I have picked, you have frustration, force majeure, and limitation of liability provisions that are very important when it comes to contracts. The frustration doctrine or frustration in civil law and doctrine of frustration in common law is certainly the doctrine of common law of frustration in common law is rarely used or sought out because people tend to look to the force majeure provisions and the termination provisions before they would ever try and argue frustration, because frustration is so hard to obtain in common law. In civil law jurisdictions, obviously you have legislation, but again, my understanding is that it's a little bit more difficult, and therefore the force majeure type legislation is generally the one that people revert to, and obviously you can have a contract that a court will take account of in many civil law jurisdictions. In terms of force majeure in a common law jurisdiction, it can be quite complex, and that a lot of the template force majeure provisions still do not really adequately provide for what happens. In many instances, what the force majeure does do is allow a renegotiation of significant parts of the contract, because, for example, in many construction type contracts or project rollout contracts, a force majeure will lead to a change control where the parties have to come together and look at new milestones and new delivery dates and new pricing because of the impact of the force majeure. So for a party that carries the main obligations in a common law governed contract with force majeure provisions, the force majeure provisions can be a lifesaver. The other thing that's caused a little bit of problems is because in a pandemic, legislation is rushed through, it can be unclear of how the force majeure is going to, how that the provisions actually operate in a context of not knowing whether you actually have a force majeure event or whether only part of the contract is hit by the force majeure. And that has been problematic because some instances you've seen one party provide a force majeure notice and the other party just assuming that the force majeure notice applies across the contract, where in fact that force majeure notice probably only covers the obligations of the party who's issued the notification. So you may have a situation in common law jurisdictions where both parties should be issuing force majeure provisions to cover their respective obligations, and therefore then activate fully the force majeure provisions. But as I said, it's not cut and dry, and in a pandemic you have to look at all your options. So the main options in a pandemic is obviously termination rights. We obviously haven't gone through those, but it is important to look at them. But force majeure in a common law jurisdiction has become vitally important, and it really does come down to interpretation, whereas civil law jurisdictions tend to allow people to rely more on legislation, but they can have the contractual provisions to help them out. So that brings my slide presentation or webinar to an end. Apologies for the late start. We had some technical issues. I'm going to open up the floor to any questions, if you would like to ask any questions.
So Cian, first and foremost, thank you so much for such an interesting topic and presentation, especially as we are all confined in our own homes. So there are a few questions in the chat box. It's on the bottom right corner of your screen.
Yes.
So the first one is of course, Karen asked, will the slides be available to us later on?
Yes, I've provided them to you, Martin. If you want to then provide them to anyone, I'm not sure.
Then we can distribute it to the registrants to their email addresses.
Yes,
that's fine.
No problem.
And so the next one is from Mauro in Milan, and then he is asking. It actually evolved into a discussion, but essentially where a government is applying a generalized lockup involving some of the activities necessary to perform the contract, can we invoke legislation instead of a pandemic as a force majeure event?
Yeah, well, that comes down to the legislation itself. So obviously, I'm a common law jurisdiction lawyer, but when it comes to civil law, you obviously can, if it comes within the legislation, but that again could be problematic because, as you say, that it could be partial lockdown or whatever. That's why force majeure provisions in a contract can be of more assistance, but it all comes down to whether you get within the definition. So my preference, but I'm a common law jurisdiction lawyer, is to try and work within the contract, because in Ireland and places like the UK, you don't, England and Wales, you don't really can't really revert too much to legislation when it comes to force majeure. But in civil law jurisdictions, you probably need to make sure to look to legislation first, to see whether that assists, and then obviously layer on top of that your contractual provisions.
And sorry,
just see there that I see there that Stephen Barth agreed with me. Yeah. So, but he had said that already, so it looks like I'm copying.
Exactly. And then there was another question asking whether the current pandemic will lead to force majeure be defined differently in future common law contracts.
I believe so, yes, because there's two things that have arisen problematic is that you have situations where you have, first of all, the definition. So if you look through a lot of common law jurisdiction contracts, you won't see the word pandemic or endemic too often, but you do see it. But it's not something, a lot of parties believe that comes under definition of act of God, other parties don't. So therefore, it comes down to having non-exhaustive list, but it just helps when you're defining something. If it's one of the examples given, even though it doesn't necessarily have to come within the examples where you're providing the language which is typically used, which is a broad one where you say something beyond the reasonable control of a party. And has the other elements of a force majeure, and it says including but not limited to, and it gives a list of events. So I do think the definition of force majeure may be changed moving forward. In terms of the body of force majeure, I think it'll just highlight the main provisions of force majeure. I think it'll highlight the necessity of having some kind of clear business continuity plans. In more detailed contracts, you will definitely see the link between force majeure, activation of force majeure, and business continuity. There are also maybe some changes around a lot of force majeure provisions are unclear, where you notify them. You notify of a force majeure, and then you have to then also give kind of subsequent to that then an impact. So that is something where a lot of contracts are deficient in, common law jurisdiction contracts particularly, are deficient in but it's problematic. And this is where I think moving forward, there will be a lot of discussion on, is particularly something like COVID-19 or a pandemic. People actually don't know what the future holds. And also, we know that it won't be like a light switch. So in many instances, force majeure provisions are drafted from a perspective of the event ceases. But in a COVID-19 or pandemic situation, which we are witnessing now, we have a situation where things ease, and there's kind of like partial lockdown and there are different measures. So that makes it more complex. And whether that leads people to draft more prescriptive force majeure provisions or have them even more open-ended, will be interesting to see that development. Now, I believe that we may see a little bit more open-ended as a result of this pandemic.
And then, so we have two more questions if you have the time.
Yes.
So we have a question from Linda from Sweden asking, where can you find guidance if a common law contract doesn't include a force majeure clause?
Well, the guidance is that if you don't have a force majeure provision, then you're only my next step would be to look at the termination provisions. I always think the first step should be to look at the termination rights, because one thing about if you have a termination for convenience right, that means you can terminate without there being a breach or anything, and it's relatively short. Sometimes that can be used to leverage discussions to open up the contract. It's very clunky, it's not ideal, and it can result, it depends on how you do it, it can result in things going down the wrong path. So it's a tricky situation to develop. In terms of if the contract doesn't have force majeure, then, and you're in a common law jurisdiction, you then look at doctrine of frustration. And as I said, that's quite difficult. That means that the contract, basically, you're saying that the event is such a supervening event that it has caused a radical change to the contract. And a lot of people believe that that the COVID-19 pandemic situation doesn't give a rise to frustration unless it's something like, for example, someone who's going to a band to sing at a venue and you have lockdown, well, and it's on a specific date, you can say that that contract is frustrated, you know. But there's other stuff like delivery of goods and everything that are allowed. You have essential services that are allowed to continue. So if the contract doesn't include a force majeure clause, you've got termination, you look to legislation, and you look to the doctrine of frustration. They're the main ones you look to. And maybe there's some kind of change of control, but not provisions that allow you to go back where extra costs have been layered. But again, that's a difficult one. So you're in a bit of trouble in a common law jurisdiction if there's no force majeure and you don't have a short termination right. That definitely causes some issues.
And the last question is from Julian from Ireland, asking, what about force majeure being raised for payment difficulties, despite it being excluded in the force majeure clause? Contract governed by Irish law, but the country in which it is performed have closed the banks, making the purchase of euro and cash flow difficult.
Well, then that comes down to, like, I mean, the problem there is that you're not covered by the force majeure, it is specifically excluded. My understanding is that payments can be made. It depends on what the setup is. The reality of that is that unless that party who's not paying or cannot pay for whatever reason, they will still owe that money. And on top of that, then you would apply. Normally, there's a clause that has an interest. So if there's no clause with interest, typically in common law in European countries, you have, I think it's 8% above the ECB, so you can apply that interest rate. Or there should be a non-payment or late payment provision. There's also a termination right. But I wouldn't have thought that, given that a party is saying they can't pay, that there's technical difficulties or whatever, that means that they don't pay or aren't obliged to pay. So you have a contractual right to receive that payment. They're saying it's impossible for them to make that payment. I would say in a pandemic or COVID-19, it's rare, given the way payment systems work, that payment can't be made. They'd have to try and see if they argue that there's supervening legislation in their jurisdiction. But I believe that they still owe those monies, and I still believe that you would be able to get them to apply. You could apply interest to that late payment, because I don't think that payment obligation is frustrated as such. So I would definitely be going down the path of trying to obviously find a workaround solution. But I think it would be if they have legislation which stops them, but you have a contract governed by the laws of Ireland, your contract takes obviously priority or prevails. The problem you have there is if you go to court and you get a judgment in your favor, it's trying to implement it in the applicable jurisdiction if it's outside of the European Union. So that's just something on that one.
Okay. Thank you very much, Cian, once again, and we have a lot of positive feedback in the chat box as well. Thanking you for hosting this brilliant session. And for the viewers, our next session will take place on Thursday at 11 Central European Summertime, where we will have Mr. Jean-Philippe Doho talking about legal innovation. I hope that you will be able to join us then as well. And then if you do have any other questions for Cian, feel free to write to us, and then we can forward them to him as well. Cian, would you like to say a few words?
Yes, I'd just like to thank you, Martin, thank the ECLA, and thank everybody for listening. I hope you all and your families stay well, and hopefully this pandemic will be over. This webinar on pandemic will be seen as to be useless, because no other pandemics arise again that are of serious significance to impact our lives the way they are. Okay, everyone stay safe.
Thank you, and have a nice day to everyone. Bye.
Take care, everyone. Bye-bye.